the paragraph about the complainant says he kept demanding to know the penalty, or he kept demanding what the penalty is, and I think the words "to know" should be inserted between demanding and what.
Okay. I have in item number 9 near the bottom of the page, page 8 of the packet, the third line, Olata and Calander Scott represented the Tide Center and said a dedicated telephone line has been installed for interested members. That sounds like there's some physical installation of some particular equipment, which I don't think is what she meant. So it probably should read, said a dedicated telephone line would be available for interested members of the public. Also, I believe that on the next line, east for East Coast, I think east should be capitalized.
Well, east and coast.
East and coast, okay. I have another one I'm not as sure about. Item number 5 on page 7 of the packet. It's the fourth line down. Reading a little bit earlier, the budget was trimmed across the board as requested by the mayor with a few hours added or deleted. So I'm wondering about the word few, whether it should just be, say, hours, because few is indeterminate, and there might have been instances where more than what we would think of as a few were added. I don't know. Member Nee?
Well, Madam Chair, it depends on what Mr. Song said.
Mm-hmm.
The minutes are reflected are intended as a reflection of the proceedings, and I think before changing that, we would need to go back really and see. I have no problem with deleting it, but it depends on whether it's whether doing so would change the thoroughness and or accurateness of the minutes.
Right. Yeah, I remember a lot of discussion back and forth about that, and Henry talking several times about the hours. So I guess
if he said a few, then I would say leave it.
Yeah, I see what you mean. So maybe that could be checked. It's not a tremendous big issue, but
well, in that case, it might be appropriate to continue the minutes. If there's a question, I mean, this is a substantial matter, and typos are one thing, but where there is this kind of a question, I think, unless we want to just accept it as is, I think if there is a legitimate question, I think continuance would be appropriate.
okay. So are you moving to continue?
No, I'm not.
You're not. Okay.
If somebody else wants to move, I'll be happy to go along with it. But I
actually don't feel strongly about this.
Okay.
So why don't we let it go? I'm happy to let it go, unless the members of the audience or the members of the public can argue otherwise. Okay. Is there any public comment on the minutes from our last meeting of December 13th?
Yes, my name is Jason Grant Garza, and I just want to put it in the record. I'm not really sure about the comment that was said earlier about me demanding to know if it was, I don't even know if it was I who was demanding to know what the penalty was. I want it reflected on the record that I would never received an answer.
Are there any additional public comments on the motion to approve the minutes? Seeing none, Ms. Johnson, could you call the roll, please?
On the motion to approve the minutes, Member Snyder, I'm sorry, Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Chair Washburn?
Aye.
Washburn, aye. Madam Chair, there are 3 ayes. The motion passes.
Ms. Johnson, could you call the next item on the agenda?
Item 3, continued hearing on the status of the October 25th, 2011 order of determination of Alan Grossman versus Dennis Herrera and Jack Song of the City Attorney's Office.
Okay, at this time, Mr. Grossman, you have 5 minutes.
I don't see Mr. Song or anyone else from the city attorney's office. Do you want me to go ahead anyway?
It's
I just as soon go ahead.
okay. Yeah, it's really your call. I don't know. Was there any communication to staff, Ms. Johnson, as far as you know about?
None that I'm aware of.
Yeah, I think that I may have the answer to their non-appearance, so
Okay. All right. So
let me just go through what I've prepared.
okay. Oh no.
At the last Compliance Committee meeting, Mr. Song continued to insist that there were no records of any kind that related to the 3 letters from the city attorney to the Sunshine Ordinance Task Force or to any of the other general fund departments, notifying them of reductions in hours of their assigned deputy city attorneys. He left before the hearing on the complaint ended. At my request, the matter was continued to this meeting to allow me time to consider other approaches to obtaining some relevant records. On December 15, I submitted a records request for records that would identify the city employees who were involved in any way in either the preparation or transmission to the addressees of any one or more of those letters. That's 3 to the task force over 3 years, or 59 in 2010 to the, or 2009 actually, to the city fund departments as they're called. 2 weeks later, I received a copy of one email from Scott Minty to Marisa Murray, dated December 16. If you look in your packet, that email is page 23 in the packet. That email disclosed that 3 persons in the city attorney's office may have had some hand in the preparation of the letters: Scott Minty, Marissa Murray, and a Susanna. Because the email was dated after Mr. Song received my request, in other words, I sent the request in on the 15th of December, and I got an email back, copy of an email, that was dated December 16, I assumed it was not a copy of the original. So I wrote Mr. Song and asked him for a copy of the original dated email and for the job descriptions of the 3 persons mentioned in the email. He responded that the email copy he sent was in fact the original one, and he provided me with copies of their job descriptions, and those are on pages 15 to 20 in the packet. Page 21, however, is an example of an original dated email from Mr. Minty to a deputy city attorney in the city attorney's office. And it looks like any other email, not at all like the remanufactured one I got from Mr. Song. So what we have is a mystery. Of course, Mr. Song isn't here, so we may
Yes, he
not
is.
get the
He
answer.
just came in.
Okay, so maybe we'll get the answer from Mr. Song. Once I had the names of the 3 persons in Mr. Song's office who should have had firsthand knowledge of how these letters came to be, I submitted a records request to each of them a week ago, asking for records in their custody that related to the preparation of those letters. Although the week has gone by, and I asked that the responsive records be sent on a rolling basis, I have received nothing to date. What I did receive is a somewhat nasty letter from Mr. Song. Apparently, he has decided that my request for records regarding the original general fund budgets that resulted in reduced hours for the task force would no longer be responded to. Apparently, he believes that I'm not entitled to pursue inquiries that would explain why the Sunshine Ordinance requirement for an assigned attorney was cut back so dramatically based on some budget fund calculations. While his letter is not relevant to this hearing, it confirms the city attorney's lack of respect for the California Public Records Act and the Sunshine Ordinance that we have seen over the months as I've attempted to find out whether there really are no records of what the city attorney has represented he did in his letters to the task force. So I thought what I would do is read a couple of portions of Mr. Song's letter. I actually have copies if you're interested to follow it.
If you would, yes.
I can do it later. I'll distribute it later. In his fourth paragraph, he says, the past 6 months, our office has received more than 12 immediate disclosure requests from you. 12. According to my calculation, he received 6, including the last 3, of which 2 were immediate disclosure requests. I think Mr. Song is confusing a letter response from me as an immediate disclosure request.
Mr. Grossman, your time is
Almost up?
It is up, so if you could
Okay, well,
just wrap up, please.
then I'll just go ahead. But at the end of the letter, he says, that's it. I'm not going to get any more information, no matter how many records requests I submit on this subject. So he also suggested I come to his office to get the facts. When I can't get them through records, that document the process or who was involved, I think is fanciful at best and unacceptable. Secondly, I think at this point the situation is we now know 3 persons in his office probably have knowledge of what happened or what didn't happen. It appears Mr. Song sent a doctored email in response to a records request, and logically there should be others in response to that one. And Mr. Song, as proxy for the 3 managers who are the real custodians who have knowledge of what happened, has stated that they will not respond to my records requests. I don't think there's been compliance.
Thank you. Is there anyone present to offer facts and evidence in support of the complainant? Okay, seeing none, the respondent has 5 minutes.
Thank you. I would like to give my time to Mr. Grossman to make his case, and I will present my case step 4 of our presentation, which would be, I think, during the rebuttal. All right? Thank you.
I'd like to consult with my fellow members. I haven't been faced with this situation before.
If Mr. Song does not wish to make his presentation at this time, I would suggest, Madam Chair, that we ask if there's anybody to present facts and evidence in support of the respondent, and then we go as normal. We ask questions, then we take the rebutting and concluding statements, and then we bring it back here for a possible motion.
Okay. Is there anyone present to offer facts and evidence in support of the respondent?
Hello, my name is Rita O'Flynn, and I wanted to stand here and speak in support of Mr. Grossman's experience.
Oh, excuse me.
Yes?
Actually, maybe there was some confusion, but this is time for the to speak in support of the respondent. But now I'll run into
I'm
another
sorry.
issue. Just a minute. No. Could we permit her to speak
Just
now?
have her step aside and ask if there's anybody here
Okay.
to support.
Is there anyone here to that offer facts and evidence in support of the respondent? That is the city attorney's office, represented by Mr. Song. Okay. Member Wolf. Okay. Ms. O'Flynn?
This is for the
For
complainant.
the complainant, Mr.
Yeah.
Grossman.
I just wanted to let you know that the circumstances and the experiences that Mr. Grossman has encountered in dealing with the supervisor of records is not limited just to Mr. Grossman. I, too, have been subject to blatant violations of the Sunshine Ordinance, which I believe are also violations of California Government Code 815.6 for a failure to discharge a mandatory duty imposed by enactment, which is what the Sunshine Ordinance is. And I would hope that this commission can find a way of enforcing the law and making the city attorney, who is our supervisor of records, do the job that's described in the San Francisco Administrative Code and provide the materials to Mr. Grossman as he's legally required to do. Thank you.
Thank you. Okay, at this time, the matters with the task force, or the committee, rather. I have a question for Mr. Song. I'm looking at page 23 of the packet. There's an email from Scott Minty to Marissa Moret. Could you tell me about this? Is this something that you sent to Mr. Grossman?
Yes, that's something that we provided to Mr. Grossman. I believe that was the date that appeared on the email was the print date. That was what I recall. And that's what we have provided to Mr. Grossman.
So there's no record of when it was actually sent?
No, that original email was not. Did not locate that. We had to go back to our sent file, and that's what was provided to me.
That's just irregular in my experience not to have a date there.
I can
That's
look
why-
into it, but that was just what was presented to me. That was the hard copy that we had on file.
And so after our order of determination and after Mr. Grossman's efforts to obtain the information that he requested, this is what you provided to him?
Actually, he requested additional information on the job description on the 3 individuals that were named in one of our documents, and we provided those to him. And he also asked for additional documents, and we did not have responsive documents to his request.
So it's my understanding that of this case, which has become very convoluted, but I think it's really pretty straightforward, at least in my mind, is that Mr. Grossman wants to know how budget decisions are made in the city attorney's office. Those decisions affect this task force ability to do our work. It affects every single department. And so he was given many, many letters, and he wants to know, well, where did the figures in the letters come from? And so this is what you were able to, these documents represent the budget justifications, in your words.
You're looking at one piece of paper, and this has been ongoing for the past 6 months. And really, it was until December 13th at the last task force hearing that Mr. Grossman's true intention was explicitly shared with the public, with the task force. He basically wanted to know how the city attorney's office was unable to provide the Sunshine Ordinance Task Force with a full-time deputy city attorney. But through his quest of requesting information here and there, he was trying to determine on his own the reasoning behind the budget cuts. And I wish he had been upfront right from the beginning. Can you explain to us how does the budget work? With the budget cuts, how come the Sunshine Task Force cannot have a full-time deputy city attorney? I wish he would have been clear. However, back in June, we knew that was probably his intention. What we have provided were documents going back to the data, going back to, I believe, 2002, of the hours that were spent on the Sunshine Task Force. And you see the variation going from some years are high, some years are low. But you get a good picture that it wasn't, despite the budgetary constraints, we tried to maintain the hour service to the task force, and we provided that to Mr. Grossman. So I hope that the task force or the committee here today can look at the overall picture of what we have provided for Mr. Grossman for the past 6 months. And I want to emphasize the letter that I had sent to him. We invited him to say, listen, what are your questions we would like for you to discuss with us? Let us know so we can explain it to you, how the budget works, how the entire, the 10% budget cut affected all the general funds that the city attorney office advised. And so far, Mr. Grossman has not taken up on our offer. And I feel that we, of course, the city attorney's office is at a disadvantage. There's a lack of trust from Mr. Grossman, but we've welcomed that communication and really hope to resolve this in an amicable manner. But it's been unfortunate that it's dragged out this long. But I counted before I came here. I believe between the correspondence documents that we provided, it's up to 131 pages or so. And that's all I have to say.
Thank you. Member Wolf.
Mr. Song, I don't know if it's your intention or not, but, you know, coming up here and doing everything possible to try and discredit Mr. Grossman does not really help the matter. It doesn't really help move it forward with regards to what the order is on the table. The order on the table is for the city attorney's office to produce documents. Do you have those documents?
When we say we don't have responsive documents, it means we do not. So I
It's
don't know
not
how
about
else.
responsive documents. It's whether you have any documents. It's all. Do you believe that the city's budget is the people's budget, that it belongs to the people, that it's a public document?
The city's budget exists on the controller's website, and the 10%.
If it exists on the controller's website, then
Correct.
Isn't it the
And,
people's budget? Isn't it a public document?
It is a public document, and that's why it's
Okay.
posted
So
on the controller's website.
And so any information that pertains to that budget, whether it's produced by the controller or not,
And we provided that.
if somebody else has, but if it was not provided in a way that allowed the member of the public or the requester to be able to use that information, and more information was requested, and that information is still public, which we have found to be true, then why still withhold it?
We provided all the documents that were responsive, and we also gone above and beyond, going back to our data, collecting how many hours were spent back to 2002. When we don't have that data, we have produced the data for Mr. Grossman.
Okay. Do you believe that the amount of time, in this case, it's speaking to the focus of the task force, do you believe that the amount of the question is whether the documents reflect possibly full-time or less than full-time work? So the question is whether Mr. Grossman can come to that conclusion. Now, whether it's his intention or not, that's not what the law is talking about. The law doesn't care what the person's intention is for using the documents. All it cares about is whether the documents are public and if they're available. And if they are public and they're available, that's all that matters. Who cares what his intention is? And why should it matter to you?
Absolutely not.
So
and
then
that's why
why
we
I don't
provided
understand?
everything we need.
Then I don't understand why you continue to bring that up. You made it very clear to make that a central focus of your testimony. So I'm a little concerned that today. Well, let me ask Mr. Grossman. Have you received any? Mr. Grossman, can you come up, please? Thank you. Have you received any of the documents since the task force meeting that was ordered for them to produce?
No. The email was responsive to a request I submitted on December 15 after the meeting, the last compliance committee meeting. Because I still couldn't figure out, because I'd never had a name, who was involved in the process, and that was the purpose of that records request.
Okay.
And I got the 3 names out of that doctored email. I call it doctored because it should have its original date. And I think the original date would be helpful because if it really was in 2011, if it really was sent in 2011, it was totally irrelevant to my inquiry, which relates to the period in 2008, 9, and 10. So there's got to be a date that belongs to the email, and there's got to be should be some response because the email itself asks for a response.
So let me just be clear. I'm just talking about the information that the order of determination is pointing to. Specifically says that within 5 days, CAOs to produce supporting documents for the CAO's calculation for the last 2 years.
No.
You haven't received that?
No.
Not one document that's
Not
dated
not
for
one.
2009 or 2010 or 2011?
No.
Okay. Mr. Song, have you provided Mr. Grossman with any documents relating for 2010 or 2011?
That was provided at the previous packets. That information was provided, the baseline budget, I believe, for 2009 to 2010.
But we're not talking
And-
about baseline. We're talking about the breakdown.
The breakdown,
Breakdown of hours, not baseline.
I do not believe we had that information.
But we've seen documents come before us that have broken down the time by hours for an attorney representing a particular commission or board.
That was correct, and that information was shared with I believe you're referring to the Arts Commission, specifically dealing with the sunshine-related matters, the street artist program. That one was released by the client. It wasn't from us. It wasn't from the city attorney's office.
But he received it from the city attorney's office.
That is correct. But
So why
but
wouldn't you have the
client-
same document
May I
related
finish?
to this task force?
May I finish? The client in that particular case was the Arts Commission. They waived their right and they shared the document with the street artist advocates.
So I'm sorry, are you now declaring that information is privileged?
For the billing, the internal billing, yes, it's between I believe the city attorney's office and the clients that we serve, the departments.
So if we were to ask you for that information, would you be able to provide it to us?
You should absolutely ask directly to the deputy that's assigned to this task
Okay.
force.
So are you saying that is not public information?
I believe it's not. It's our policy. It's internal billing policy.
You are the city attorney's office. You are also the supervisor of records under section, I think, 6721C or D. You have the ability to determine what is public and what is not before it even comes here. So can you tell me or
I do
tell
not
us
believe
whether that information is public?
I do not believe that information is public.
Belief is different than an opinion. You need an opinion from the city attorney's office.
Then you should consult with your deputy city attorney that's assigned to this task force.
No, because that deputy city attorney we're asking you whether because you're withholding the information, you have to tell us by what standard or by what
The
citation.
internal billing policy between the different city
It's not
departments and the
policy.
city attorney's
We're not
office.
but it's not about
is-
policy. It's about what the
Attorney-client.
law supersedes policy. So if the law says that it's public, then you have to produce it, policy or no policy.
Okay.
So that's what we want to know. If the city attorney is coming here and saying under section 67 point something that information is not public, then we have something. Okay? But that's not what we're hearing here today. It's the same thing as another example. If redaction, very simple. If you come in here and you say, well, we stand by this redaction based upon section such and such. You have to do that. So you have to come here and say that information is not public information under section such and such. And then we have no problem.
Okay.
So
I am not a trained attorney. I'm not very good at citing the different case laws. However, what I can share with you, and we've done this before. We have gone through similar cases before the task force. The internal billing policy between the departments, between the client and the city attorney's office is privileged. It's internal. Just like when we work on different cases, the amount of money that we spent on a particular case is not shared until the case is closed, and we're in a similar situation.
But this is not similar because it's not based on a case-by-case basis. It's based on regular work. It's a full-time attorney. It's just a job. So how many hours is this person spending? Now, if this council was not in the budget of the city attorney, it was, let's say, in the budget of the public defender, I don't think we'd have any problem. We wouldn't be here right now. They would just provide us with the breakdown.
And we did do that.
You said it was a baseline.
Correct. The baseline was established 8 years ago. However, we've also provided the number of hours that were spent from 2002 up, I believe, until 2010.
Right, and we're talking about...
And the baseline is always based on the year before. But however, the baseline for the general fund was created in I believe, it was 8 years ago.
You're saying, but the baseline is just a single number.
Correct.
Yeah, but we're not demanding that. We're demanding that you give a breakdown, because the complainant is interested in knowing what the actual hours spent are, whatever his intention. So a baseline is not sufficient.
So now the new request is for a breakdown of the hours were spent on different cases?
It's not new. That's always been the situation. He didn't ask for a baseline. He asked for the breakdown of hours per year.
I think we need some clarification. Just a minute. Mr. Grossman, So you were specifically asking for what information?
I asked for the records that show how they calculated the reductions in hours of service that were allocable to the task force, as stated in 3 letters from Dennis Herrera to the task force, that reduced what should have been a full-time number of 1,200 hours a year to something in the neighborhood of 400 or 300, and then the second year, another reduction. The third year, there was no reduction. But the actual number of hours that they spent in any period was actually not what I was interested in. I needed to understand what the MO was on how they got from 100% to 30% or 28%, whatever it was. And somebody must have sat down and made all those calculations. And I don't care what Mr. Song says. He just doesn't get it in terms of what my intentions were. And even if they were relevant, which they're not, as you indicated. Thank you.
Madam Chair, just a point of order. I'm reading the order of determination. That is not it. The order of determination is to produce supporting documentations for the calculation of general fund department for the past 2 years. Does that sound?
It sounds like what he said in slightly different terms. And my understanding is what he's asking for is what I think of when I've done budgets for grants, for example. It's a budget justification. So you name a number, and then you have to explain how it is you came up with that number. So that should be documented somewhere, somebody has the authority to make that determination.
Okay, then I misinterpreted the order.
Member Snyder.
I think it's easy to get confused about what our job here in the committee is, and our job here is to simply determine whether the city attorney's office has done anything to comply with our order. And our order, as Member Wolf just quoted, is to produce supporting documentation for the city attorney's office calculation of each general fund department's budget for the last 2 years. And the testimony that we received today is that they have not produced anything further on that question than they did at the task force meeting. And so I think our answer here, or our action here, is pretty simple. It's to find that there's no compliance. It's a little confusing because Mr. Grossman asked for further documentation, which of course he's fully entitled to do, and the city attorney's office responded to that further request, which is great, but those aren't relevant to what we're talking about here. All we're talking about here is whether they've complied. And Mr. Song, could I ask just a quick question? So did you read the order of determination?
Yes, and we had alerted Mr. Grossman that what we provided back in, I believe, August or July of last year were a letter to all the general fund departments stating the numbers of hours that were allocated to the departments, plus the reason why there was a cut to the hours, which was the general 10% cut across board to all the general fund, and that was something that came out from the mayor's office. That was instructed to our office. The letters that Mr. Grossman received that were directed to the departments, the commissions, reflected that. And we also specifically in the letter said that all the department heads are welcome to meet with the assigned deputy city attorneys to see if they need more hours, how we can better allocate more hours to the department.
Is that letter in the record here?
Yes. Well, no, it's not in this packet, but it was provided in the previous full task force hearing.
So my question is, since the task force meeting, have you since whatever it was December?
Yeah, we alerted Mr. Grossman that what we had provided before was responsive to
All right.
what.
So you didn't produce anything in addition.
What we had produced was follow up to Mr. Grossman's requests.
To his new requests.
Correct.
But you didn't produce anything new in response to the fundamental, the
No.
underlying request.
No,
to produce
we
this.
alerted him that.
Did
what,
you search
what was
for
already
further
provided.
documents?
Absolutely.
All right. Well, so I mean, it seems to me the answer is they didn't produce anything further, and so our answer is that there hasn't been. It seems to me there hasn't been compliance. The order says produce documentation as to the calculation. They produced some documents, but those were in response to Mr. Grossman's later requests. And like I said, that's great, but that's not what the order of determination asks for. And so it seems to me that there hasn't been compliance, and so the question is, what do we do about that? Assuming everyone agrees that there hasn't been compliance.
No, I tend to agree. We discussed this at great length with the full task force, and we determined that it just defied all reason that there was nothing else, no supporting documentation for those letters. And so voting such, we issued this order of determination requesting further documents. And I agree, there has been no compliance here. Anything further? Okay. At this time, Mr. Song, you have 3 minutes to offer a rebuttal.
Sure. I just want to add that at the previous task force hearing, there were questions of were there scratch papers or calculation? How do we come up to this number? This was all generated across the line, 10%. That's what we have provided to Mr. Grossman. Those were the letters. Those were the baseline budget for the year for 2010 to 2011. So what we have provided for Mr. Grossman, I believe, were letters from 09 to 2010. I feel like that our office have provided all the responsive documents that we can provide, and I also believe that our office has explained to Mr. Grossman the way the budget, the overall city budget works, and how the city attorney's office allocates its hours to different departments. And again, I want to emphasize, lastly, that despite that different departments are allocated a certain hour, our office always try to exceed the allocated hours, especially with this particular task force in previous years where the allocated hours were exceeded, but we still provide service, top service to this committee, this commission. And with Mr. Grossman, personally, I've really tried to work really hard with him. The first request came back in June, and we provided what we thought was responsive at the time, including going into our database, producing document that would have been still responsive to what he is asking today. But we almost predicted that we guessed that was what he was asking about the different hours. He was concerned the hours were being cut from the city attorney's office in advising this particular task force. And we assured him that that was not the case, and we shared with him the hours that were generated based on our data from before, and that was something that we was not required to do by the ordinance, but we went ahead anyways and went into the data, pulled out all the hours, the billable hours, and produced that for Mr. Grossman. So I sincerely hope that if Mr. Grossman has further questions, I'm more than welcome. I'm more than happy to provide whatever else we can. But at this point, we have no more responsive documents to his current and last request. Thank you.
Mr. Grossman, you now have 3 minutes.
I think that anyone who would accept Mr. Herrera's statement in his first letter that the reduction to 350 hours from probably like 1,200 was reached after a careful review of the historic levels of service your department received over the course of the last fiscal year, several fiscal years. If you believe that is true, and you also believe that what Mr. Song says, that they don't have a piece of paper in the entire city attorney's office that relates to that statement, then I don't know what else to say about that. I will say this in rebuttal, that Mr. Song originally told me to go to the controller's website and pull the budgets for the years involved and the baseline year and see what happened, to just demonstrate that if you did it on a kind of macro basis, you would see these reductions. In point of fact, if you did that, there was not a reduction. There was 140% of the 100% from the baseline. In other words, in 2008 and 9, it was up 40%. 2009 and 10 it was up 17%, and 2010 and 11 it was up 4%. I didn't see any 60% reductions or 40% reductions in general fund support to the city attorney's office in those budgets, reflecting their inter-department recovery and the total revenues that they received. So even that approach, which he insisted that I do, produced a contrary result. I don't know what's going on there, and I don't actually care in the long run. I think, from my point of view, I think this is just another demonstration of how the city attorney is undermining the task force. And the fact is that you should have a full-time attorney. It's called for under the statute. He should be your lawyer. You should be his only client unless you say he can handle other matters. And he should be your advocate. And the fact that they are fumbling this around and suggesting all I have to do is go to their office and they would explain to me makes no sense. I've been over there before, and believe me, Mr. Darcy gave me a runaround like you wouldn't believe. Thank you.
Thank you. No, not at this time. Not at this time. The matters with the task force. Do I hear a motion? Member Nee?
I'm not ready to make a motion yet, but it seems to me that Mr. Song should not have left the room in case we have more questions for him. And that, to me, constitutes violation of 6721E.
How do you want to proceed with that violation, Member Nee?
Well, to me, I think Mr. Snyder, Member Snyder, laid it out very clearly. The question before us is whether there was compliance with an order of determination. And clearly, there was not. You know, through all of this, they've been claiming there are no responsive documents, that you know, they somehow just relied on baseline budget from one year to the next without really explaining it. And as Mr. Grossman pointed out, he received a letter from, correct me if I'm wrong, Mr. Grossman, Mr. Grossman received a letter from the city attorney saying that these amounts are based on some very careful calculations. Is there very careful consideration data?
That I read from the letter in 2008 that was sent to Frank Darby by Dennis Herrera. It's in the file. It's part of the complaint.
Okay. But in that letter, Mr. Herrera stated that the amounts are based on careful calculations, or is that the wording you used? Careful review of historic levels of service, and that to me speaks to the fact that there is some data there that was relied on, and that data has not been provided to Mr. Grossman. There are some violations listed here in the order of determination, and what I would like to do, what I am doing now, is to move to refer this matter back to the task force with a recommendation for referral to the Ethics Commission. With a request for enforcement of our order of determination.
I'll second that. Just to clarify, for all the items plus 6721E for Mr. Song. So we have Mr. Song for 6725A, 6721C, and then City Attorney Dennis Herrera for 6726.
Well, that's correct, but if we were referring for enforcement of the order of determination, then it's implicit therein.
Did you want to add in 6721E as you mentioned?
Well, we can't add that to the order of determination. We can say, in addition, we find the city attorney's office in violation of 67.21E for absence during the latter part of our deliberations.
As part of this motion or as a separate motion?
Part of this
Part of this motion? Okay, that's fine.
part of this motion.
All right. Is there any public comment on the motion before us?
Yes, I'm glad you asked for public comment. My name is Jason Grant Garza, and I cannot begin to contain my laughter at this entire rigged farce process. You know, I believe that Mr. Grossman will never be satisfied. And the reason that Mr. Grossman will never be satisfied is for the same reason I will never be satisfied, because this committee, its members, and everyone else is ineffectual. Yes, you'll go ahead and go through the song and dance, and you'll wash your hands and do what's required. But in the end, the outcome will be that you'll send it up to the Ethics Commission, which will overrule you. And Mr. Grossman, after spending all his Herculean time and task and effort to get something that was going to even help you guys didn't even help him. It's beyond amazing. It truly, truly is. And the most disheartening thing of all of it is that you get up here and you pretend to provide civility and dignity, and I don't believe Mr. Grossman has received any of that. Dignity and respect has to be earned by performance and by outcome. And all I see here consistently is nada, zip. Oh, we've ruled in his favor. We've done everything we were supposed to do. Of course, that doesn't provide anything in the end, and of course we know that. But isn't it magnificent of us to provide this farce and this illusion for Mr. Grossman, to have wasted 6 months of his time? But I'm sure you will continue.
Thank you. Are there any additional public comment?
Good evening, task force members. Thomas Piccirillo. Could you repeat the motion that's in that you're going to vote on? I'm a little confused, a little mumbling, and you're adding on things. Could you just tell the members of the public what your motion is, please?
Yes, sir, through the chair. My motion is to refer this matter back to the full task force with a recommendation that it be referred to the Ethics Commission with a request for enforcement of the task force's order of determination and an additional finding of violation of 67.21E for absence during the latter part of this committee's deliberations.
Right. Well, some members of the public don't have the Sunshine Ordinance memorized as the 6721E. I don't recall what that is. I am a little troubled, though, that Mr. Grossman's complaint was against both the city attorney and Mr. Song. So you have two respondents. I don't see the city attorney here or anybody speaking on his behalf. Certainly Mr. Song cannot speak for the co-respondent. So I'm a little troubled that Mr. Grossman can have a complaint against the city attorney himself, not the city attorney's office, but Mr. Herrera. Mr. Herrera is not here. So I would think that it would be appropriate that there would be a serious and willful noncompliance with your order of determination. If you recall, last month I wasn't here, but your minutes, you discussed this matter for over an hour, and what you determined was that you made another order requesting somebody from Mr. Herrera's office who was knowledgeable present tonight. I don't see that person here. So when you give orders, you should attempt to enforce them. But I think a serious and willful violation is appropriate here for Mr. Herrera or his representative not being here, and then the additional order you gave last month for somebody to speak that is knowledgeable of the facts. Thank you.
Thank you.
Hi, Task Force members, Kim Crossman. I'm kind of coming into this at a late stage, so I might not be informed with my comments, but a couple things that I picked up, or at least I thought I picked up in this hearing today. It's not clear to me that there's actually proof that there's additional records to be provided. Yes, they should have records to document what they did. And yes, they claim they did a detailed, thorough analysis, but maybe they didn't. Maybe they just put the numbers in a spreadsheet and did 10% or whatever they did. And maybe even if they did all do that, those records may no longer be around. They may have just been not retained. I just don't see that there's any proof. I mean, this has always been the issue that I've had, is that how do you, unless you have some other outside proof, how do you have proof that they're withholding records? You know, how do you know that those records that should have been created from based on what they claim occurred are still in their files? I don't know that I can't see how it's been established. And certainly the DA is going to ask you that question right away if they're going to take this reference serious. Same as ethics. Ethics is going to say, what proof do you have that they have records that they haven't provided? Obviously, Mr. Song is not the city attorney's star player, and he didn't handle himself well here. But that's probably part of their tactic here in not wanting to say things that they can't get out of later. He said that they did another search after your last order determination. If that's true, then there should be records of the hours the attorney spent searching through files. I think you'll find that they didn't do an additional search. And my impression, I could be wrong, is that Mr. Song's not a managerial employee. So I think there's been that whole issue of that you can only hold people that are, I think, department heads or managerial employees. I can't recall exactly how, or elected officials, I can't recall, but there's a certain limit on the types of people you can hold accountable. So I'm not sure they can really hold him accountable for the actions aren't being provided by the state attorney's office. So again, I don't know what proof has been provided in the past before this hearing that there actually are records that they haven't provided.
Thank you. Is there additional public comment?
Good afternoon. My name is Douglas Yep. I lived in San Francisco for 59 years, and this is my first time listening to one of your sessions. The reason why I'm giving a comment on this item is not because I have vested interest one way or the other in this item, but I was very affected by Mr. Garza's cynicism about how the process does or doesn't work. I would like to inform everybody, for the record, that the system is supposed to work, and eventually it will work, and the only reason it will work is because of people that are dedicated to see that it works. According to my interpretation of Mr. Song's action, it is nothing new for the city attorney to conduct that office today. In my opinion, one of the three things I focus on in my last 5 years of being at City Hall is it seems like everyone basically ignores the way they're supposed to act and basically tries to get away with three interesting concepts. Number one, obstruction of justice. Number two, dereliction of duty. And number three, abuse of power under the color of authority. In my humble opinion, the reason why Mr. Garza feels the way he feels is that he has intimate knowledge dealing with the Department of Public Health in regards to those three following ideas, or the three previous ideas. For the record, I worked at San Francisco General Hospital for 20 years, and for the last 5 years, I've been here working on different ideas. So my public comment is that hopefully you will do your job, and I have confidence that you will do your job. Thank you.
Thank you.
Madam Chair, I realize that it's really not a good idea to raise a point of order during somebody's speech, so I refrain from doing that. However, the gentleman who just spoke made no reference to the matter that's before us. His remarks, you know, while they're not objectionable in any way, they were really irrelevant to the matter at hand. And I would hope that other speakers, when a matter is when an agendaed matter is before Mr. Yap's remarks would have been suitable for general public comment.
Right, I was just going to mention that we're going to have that soon.
But for this particular matter, they were irrelevant, and I think it's important to note to members of the audience that when they are speaking to an agenda item, their remarks should be relevant to that item.
Is there additional public comment on the motion before us? Okay. Ms. Johnson, would you call the roll on the amendment, please? I mean, on the motion.
On the motion to send this item to the full task force, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Member Washburn?
Aye.
Washburn, aye. Madam Chair, there are 4 ayes.
All right. At this time, I'd like to take public comment on matters that are not on today's agenda. Each speaker will have 3 minutes.
Hello, again, my name is Rita O'Flynn. I wanted to take a moment to thank this subcommittee and the Sunshine Ordinance Task Force for their efforts in the matter of O'Flynn versus the Mayor's Office of Housing. My personal experience was such that I came away with the impression that you gave thoughtful, careful consideration of the matters brought before you, the evidence presented, and how it relates to the San Francisco Administrative Law Code regarding open government. This process for me began in 2008. Unfortunately, it's 2012, and I still don't have those records. However, my experience with the task force was perhaps one of the most positive ones I've had in this matter so far. While I haven't gotten the records, I'd like to share with you that the city attorney's office was actually Johnny on the spot once you did issue an order of determination in 2009. Within 21 days of issuing your order of determination, the city sued my husband, but not me, in a matter related to the records that I was seeking. Now, I don't know. I could argue that there's retaliation or not. Certainly they're within their rights to pursue their legal rights. However, I thought you would find it interesting that recently the city offered to settle the matter with my husband, provided I give up my rights to make any claims against the city. I don't know, I can't speak for anybody else, but I'm not giving up my rights, and I want to thank you for all your support.
Thank you. Is there additional public comment on items not on the agenda?
I actually want to talk about just 2 things, the role of the city attorney and the assigned lawyer, and the responsibility of the clerk of the board for administration. I think what's happened with me in my case and what's going to happen when the ethics regulations are involved will demonstrate that the task force has been slowly but surely undermined by actions of both those people. In the case of the city attorney, it's been the relentless reduction in time of the assigned lawyer and the fact that the city attorney does not recognize that once that lawyer is assigned, he or she is no longer under the supervision of the elected city official, but rather he works for the task force and is its advocate, and therefore he responds to its requests as any lawyer would do to his client. Of course, we know that hasn't happened, and it's gotten worse, and this meeting is an example of why you need a lawyer. The other is the absence of the administrator, which has been continuous and over time. I've tried to find out how many days Mr. Rustum has missed, but since I can only do this through records, and I get a lot of pushback when I ask for records, as you know, I can't ask the question directly, because what I get is we don't answer interrogatories. So I would propose that you consider submitting a request as a task force to determine the time that Mr. Rustum has missed over the last calendar year to demonstrate one aspect of the one reason why so much of your work is not handled properly. There are many other reasons, but this is not the place for me to go into it. But the point has to be made that you're not getting what the Sunshine Ordinance requires. You're not getting the support from the clerk, which is clear you should be getting, and you're certainly not getting a lawyer who works for you full-time.
Thank you. Is there additional public comment?
Yes, once again, my name is Jason Grant Garza, and I'm here to offer what I offered you guys, I think it was in 2006 and 2007, after the Department of Public Health basically denied me medical services and had an Impala violation, which I took them to federal court, in which they lied to have my case dismissed, only to sign a confession admitting fault and guilt years later. And I'd been through this process with you guys to get my medical records so that my case could be proven, and you guys failed big time, just like you are doing currently here now. However, in 2006 and 2007, I did make a suggestion to you powerless phonies. I suggested the Orange Jude Amendment, named after my soulmate, who was the reason I went to emergency and was denied emergency services, and the unhelpfulness that I received from, of course, naturally, the Ministry of Sunshine. And the Orange Jude Amendment basically was, since you're powerless, and since all this is nothing more than minutia, to step down, to not have a quorum, to do whatever so that the process doesn't continue, and then to go to the press and explain why you're doing this, to make the public aware of your powerlessness, of the fact that all you do is injure the complainants, and you further harm them by giving them false process, by giving them hope in something that you yourself know will not work. The audacity, the nerve. You call yourselves human? You call yourselves adults? I would beg to disagree.
Is there additional public comment?
Good afternoon. My name's Douglas Yep, and I live in San Francisco for 59 years. Since this is general comment, I guess this is the proper time to speak. But anyway, the reason why I spoke earlier was in response to Mr. Garza's cynicism, so I think my comments, in a general sense, were related to his comment. But that's the background of why I spoke. It wasn't to speak out of place. Okay, in regards to general comment, the reason why I spent the last 5 years here at City Hall is because I feel that there's plenty of injustice. And that injustice was explained to me very fully by Mr. Joe Lynn. And basically, I'm here because he's no longer here. I'm going to figure out what's going on at City Hall, and eventually the true story will be known. So I think Mr. Garza is incorrect when he says that there's going to be no satisfaction. There will be satisfaction. It's just a matter of how long it takes. I'm sure most of us, especially the older ones, remember the character in the Untouchables. He was fictional, but the idea was still the same. Eventually, they will arrive. It's just a matter of time. But unfortunately, they have so many terrorists, and obviously, they're a lot more important. But let's put it this way. The civil grand jury did their job in regards to the Ethics Commission and the whistleblower program, so that's a start in the right direction. I'm not the only one saying these words. Maybe I'm not. Maybe I may be the most public person to say these words, but I assure the residents of San Francisco there will be change, and it will come eventually. And let's put it this way. If one prominent person makes a promise and breaks that promise publicly, that's another story. But there are many of us that when we say we're going to try something, we're going to keep to that promise, whether it takes 5 or 10 years, and we'll see what happens. But I think Mr. Garza is wrong. There will be change. It just takes a little more time when you try to do it ethically rather than unethically. Thank you.
Thank you. Is there additional public comment? Seeing none, Ms. Johnson, would you read the next item on the agenda, please?
Item 4, continued hearing on the status of the November 29th, 2011 order of determination of Nick Pasquarello versus Film Commission.
Okay. Mr. Pasquarello, you have 5 minutes.
Good evening, task force committee members. Yesterday, I received an email from the executive director of the San Francisco Film Commission. Okay, let me start off by saying something else. I want to raise a complaint, which I have raised before. The item is listed on the agenda as a Nick Pasquarello versus the Film Commission. We discussed this at a previous meeting. I'm still confused. My complaint is against Susanna Robbins, the executive director. She is the executive responsible under the ordinance to provide the public documents that I requested. So I have requested that it be listed in the agenda as Pasquarello versus Susanna Robbins. For whatever reason, it is not getting listed that way. So I don't know. I've forgotten how it works. Can you answer that, or do I have to wait till later to get a response about that?
Well, I'll ask a point of order. Since the actual order of determination does not specify an individual, and this was after a extensive hearing that had already taken place, I'm a little concerned by Mr. Pasquarello's assertion that the complainant, that the respondent is incorrect. So I'm a little confused about how to proceed from this point forward, considering that what has been presented to us is specifically to find the Film Commission and not necessarily a specific person.
Madam Chair?
Member Nee?
I would just suggest that we move forward, let Mr. Pasquarello finish his remarks, conclude his 5 minutes, and then go through our normal procedure on this. Facts and evidence, respondent, facts and evidence, back with the task force.
And I'd like, Ms. Johnson, if you'd restart the clock for,
Oh,
or
dear.
if you not let this detract from his time.
Okay.
So, sir, if you would proceed.
Well, okay, not to undo what we've just gone through, but I just want to say one more time for the record that my original complaint to Mr. Rustam back in August was, or back in September, was against Susanna Robbins. It was always that way. I have never changed that. But to go on, as Member Nee said, yesterday I got an email from Susanna Robbins informing me that the documents I requested were available for me to pick up at the office here in City Hall yesterday, 24 hours ago. I have these documents here. I have not been able to go through all of them. As you may remember, in the history of this whole matter that started way back in the fall, I have received 3 different versions of the documents from Susanna Robbins. The first of which was had redactions of email and phone information. The second, the second one, and I can't give you the date, but the second one I think probably came after your after your determination that she had not complied with the ordinance. The second set of documents came with redactions. With handwritten additions to the same redacted documents. The redactions were still in place, and handwritten notes were items, were put there next to the redactions. I can't honestly recall if I've been here since then, but what I received today, which is the third set of documents, do not have any redactions on them. They purport to be the original documents. And at this time, I've just spent a few hours looking over the most recent version and comparing it with the previous two versions, and I am finding discrepancies, and I have also not been able to get through all of the documents I received today. So all of which is to say, I would request that you continue this item so that I can have enough time to go through the documents that I received today.
Okay.
That's all I have to say.
Point of order, could we consider a continuance? Here, I don't see anyone from the Film Commission here.
Well, excuse me, I do have one more thing to say. I think if you will look at the record, you'll see that the executive director of the Film Commission has not been at least at one of these meetings. In fact, I think at 2 of the 3 meetings she did not either attend at all or stay till the end. I think she has shown a degree of disrespect, or maybe we could even call it contempt for this body. And it saddens me that happens from city officials, but it does happen. So I think that's really all I have to say.
Member Nee.
Madam Chair, I think it's appropriate to ask at this time if the respondent is present. And if the respondent is not present, then we can either proceed as we normally do, or we can move for continuance.
I don't see the respondent present. Is there anyone here to offer facts and evidence in support of the respondent? Okay. Member Snyder?
We could probably find a technical violation of the failure to comply because they didn't do it within 5 days of the order. But in my view, if they have complied at this point, and if the documents that they provided to Mr. Pasquarello are compliant, then we would want to take that into consideration and decide whether we're going to hold them to the letter of the order of determination or not. We have, I think, the discretion to do that. Since Mr. Pasquarello has asked for more time to review the documents that he's gotten, I'm of a mind to continue it and let him come back to us and tell us, did those documents comply? I think that's what you're asking, right? You want some more time to look at everything and see if
I just want to be sure she gave me what I asked for.
Sure. In my view, I think that that's appropriate to continue it so that we can have a fuller record, and he's the complainant, and he's asking for the continuance. She's not here. No one from the Film Commission's here anyway, so they're not. I don't see any reason not to continue.
So are you making the motion to continue?
Sure. I'll move to continue it.
I object for a moment. I'd like to ask Mr. Pasquarello a question. May I?
Sure.
Mr. Pasquarello, the documents that you've received, do you recognize them as being the same as the ones that were redacted without the redaction?
I have not been able to go through all of them. I have been able to go through a small portion of them, maybe 25%. Those appear to be the same, to be the originals of the redacted ones I received, but I have not been able to go through all of them.
Okay. I just wanted to be sure that we're dealing with the documents that were supposed to be delivered to you versus unresponsive to doc.
Yeah, they might be the correct documents that I've asked for. I mean, there is some reason to believe they may be, but
Okay.
I wouldn't have.
Okay.
I would have told you if I thought they were completely off the mark and
I
not
don't think we heard either way, so
Sure,
I just
I
wanted
appreciate
to
it.
check in to make sure. Thank you.
Is there a second on the motion?
Second.
Okay. Is there any public comment on the motion to continue this?
Thomas Piccirillo. Yeah, I don't understand. The complainant alleged a complaint against a specific person, Susanna Robbins, I believe. Yet the order of determination was against the Film Commission, a non-entity, and that is one of the reasons why there is no appearance by the respondent. The Film Commission cannot appear. So I think the continuance is in part a result of your order of determination incorrectly. If he's saying that Susanna Robbins violated his rights in terms of getting public records, then the order of determination should have been against her and not the Film Commission. Thank you.
Thank you. Is there additional public comment on the motion?
Actually, I agree with the prior speaker. I think if we've learned anything from Mr. St. Croix's attempts to massage the process by which the Ethics Commission finally does something, we will learn that unless you identify the respondent as either a city official or a department head, they won't hear it. So, and that, of course, precludes every member of a commission. But if they have an executive director or some sort, then you may be able to do it. But the point is that from now on, when these cases come up, you better identify the highest ranking person you can in a rational way, and hopefully a city official or a department head, because if you want it enforced under Mr. St. Croix's view of the rules, they are the only people you can get.
Thank you.
Hello, Rita O'Flynn. I just wanted to confirm the sentiments that Mr. Grossman was conveying. I got an order of determination from the Sunshine Task Ordinance saying that records had been destroyed and that they should be provided to me, and then this committee found the city to be non-compliant. The motion was then, the full committee then sent my case to the Ethics Commission, which took over a year to decide that the orders of determination issued by this committee and the task force were clearly wrong. I mean, after all, what do you guys know? And also specifically made mention that the order of determination provided by the task force and this commission failed to specifically mention the employees who were in violation. So I do think that there is a point that needs to be made. I don't know if it needs to be made and how the case is called, but certainly when you are making orders of determination and forwarding them on to the Ethics Commission and or the District Attorney's Office or the State Attorney General, it's probably in the interest of the complainant here to have the names of the people who have specifically done the violating included in your order of determination.
Thank you.
Unfortunately, my name is Jason Grant Garza, and I've been here before many times. And specifically speaking about orders of determination, the Ethics Commission, and what a farce this entire thing is, I specifically remember when you guys found in my favor and sent, I believe it was case 06034, the Department of Public Health had violated my rights to my medical records, yada, 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 sent it up to the Ethics Commission, And there was also a separate case, I believe, for the Nurse Ratchet letter that I received in response to the denial of emergency services when I asked the sheriff for my medical records, that the Ethics Commission overruled you and said that it wasn't willful because apparently, like Mr. Song, they can look into people's minds and know what their intent is. I mean, obviously, the Ethics Commission assumed that somebody must not have been holding a gun to his head because, it wasn't willful. Now, at that time, I believe Gina Vida was the person in charge of the Ethics Commission like Mr. St. Croix is right now, and I had sent her specifically the definition of willful misconduct from the city attorney's handbook so that she could explain to me in plain English how her contradicting statement at the Ethics Commission had been arrived at. I would like for you people to know that I never received a response.
Point of order, Madam Chair. The speaker is not arguing, is not speaking to the motion that's before us. He's speaking of his own particular experiences, and I'm not invalidating those, sir. However, if you have remarks pertinent to this particular motion that's before us regarding the case of Mr. Pasquariello versus the Film Commission.
Thank you. I understand where you're going with this. And yes, I do have particular comments. The motion which you are about to grant, Mr. Piccarolo, in this false and faked and rigged process will never get him anywhere, specifically for the comments that I have interjected as to what the failure is in this entire farce of a process, how ethics overrules you. So that is exactly why I was making those comments, so that he would know that he has no hope, because regardless of whatever you do, ethics are going to do whatever they're going to do. And when you question them, even with the city attorney's own handbook as to their definition of willful conduct, you'll never receive a response. Just like when I question your procedures, your rigged procedures here, I never receive a response. Thank you.
Thank you. Are there any additional public comments? Okay, seeing none, Ms. Johnson, would you, Member Nee?
Yeah. Couple. First of all, the in the order of determination, Ms. Robbins is mentioned several times, as a matter of fact, where it says complaint filed. It identifies Susanna Greason Robbins as executive director of the Film Commission. In other spots, her name in the order of determination, her name is mentioned. Also, at the very bottom, the CCs include Susanna Greason Robbins named as respondent. So I think that is certainly relevant to what we're talking about here.
Member Snyder.
My memory of our discussion about who was named in this complaint and who would be subject to the order of determination is that, because I remember this issue coming up. I remember Mr. Pasquariello asking about it, and I remember saying it doesn't matter who you named in the complaint, because we can issue the order of determination as to whomever the executive director of the Film Commission is. And I thought that's what our motion was for. I thought the motion and the vote, my memory is that the motion and the vote was directed at a specific individual. I may not remember that correctly, but I wonder if we should ask Mr. Rustam to double check that. Now, I realize the order of determination's already been signed, but whether we should double check that the motion was actually not directed at a specific individual, and the order should therefore not be directed at a specific individual. If it's the case that we directed the motion and the order at a specific individual, then I think we can just correct the order of determination. It may be that simple. I may not remember correctly. I fully admit there's a fairly high likelihood of that. And we may have just, the motion may have been against the Film Commission, the order may have been against the Film Commission, then we've got a different issue. But it may be an issue of just correcting the order.
In the order of determination, on the first page, it says complaint filed. Under that heading, it says that Mr. Pasquariello filed his complaint against Susanna Greason Robbins. So I think
the order itself is against, if you look at the decision and order of determination, it's the task force finds that the Film Commission violated.
Right.
I think we intended to direct this at an individual.
That's been our practice recently, because we recognize this problem. So I'm thinking right now we're voting on a motion to continue this, but I think we need to, depending on the outcome, I mean, there are a number of problems here. First of all, waiting until yesterday to give him the documents is outrageous. But at any rate, we have a continuance, and I think depending on what happens going forward, we can remedy this so that if we have to take further action, we'll make sure that we name the person that against whom the complaint was filed in the first place. It's very clear here. Member Wolf.
Yeah, I wanted to wait till public comment was done to see if this subject came up and to offer that respect, but also I don't think this particular issue necessarily deals with the continuation and wanted to get through the continuation process. I think it's incumbent upon this committee to make a directive back to the task force or to the chair of the task force to direct the administrator to make these changes. This is unusual format when there's a statement that says who the complaint is filed against and that the order of determination is not against that person. It's highly unusual. And I would just say it's been quite some time since this the task force has taken a position or made an order of determination against a particular department or body. So, you know, this is a very unusual case. I think it's somewhat of a clerical error, but yeah, I think that we need to direct this to the chair of the task force to check in with the administrator and find out exactly what's going on with this. And I don't think necessarily a special motion needs to be made for it, but I think just a recommendation from this. And if you want to make a motion for it, we can do it after we do the continuance.
Well, let's we call the roll on the continuance, and then we'll discuss this further.
On the motion to continue this item, Member Snyder?
Yes.
Snyder, aye. Member Nee?
Aye.
Nee, aye. Member Wolf?
Aye.
Wolf, aye. Member Washburn?
Aye.
Washburn, aye. Madam Chair, there are 4 ayes. The motion passes.
So back to the.
I would just I would make a recommendation. I mean, I could make a motion. We could do it like that if you want to make it formal. But I think we should refer this directly to the chair of the task force and have both her and the administrator review whether the verbiage in this, as far as the target of the violation, is correct.
So would either you or Member Snyder care to follow up on this? I don't think we need a formal motion.
No, we don't. I don't know that it's really incumbent upon the chair to follow up on this and to present it back to you, Madam Chair.
It's incumbent upon Chair Johnson.
Chair Johnson.
Right. Would you care to communicate that to Chair Johnson?
Well, we're going to make a recommendation, and then it'll get forwarded up by the administrator.
Okay. All right. So
That's the communication.
all right. So Ms. Johnson, if you would make note of that.
Yes, Madam Chair.
Okay. Thank you very much. Ms. Johnson, would you call the next item on the agenda?
Item 5, continued hearing on the status of November 29, 2011 order of determination of Jason Grant Garza versus Department of Public Health.
Mr. Garza, you have 5 minutes.
I'd like to ask for a 5-minute break because I'd like to go to the bathroom and not be on edge while I'm giving my presentation to you.
Okay, that's fine.
Will that be okay?
We'll recess for 5 minutes at 5:40. I did. I went to Florida to spend Christmas with my mom, and we went up to Savannah. The meeting of the Compliance and Amendments Committee is back in order at 5:47. Mr. Garza, you have 5 minutes.
Yes, thank you. I'm here because I want to continue to follow up on the fact that I've not received what was requested. Also, I'm here to notify you, as I had notified the administrator and I believe the task force disability representative, that the order of determination that I have was incorrect. Several things on it were incorrect, per what was stated on the tape, and I never received a response for that. Right off the bat, if you look at it, you'll see that this order of determination was adopted by the Sunshine Ordinance Task Force on July 26, 2011, page 3. Right off the bat. And if you look at the date that the decision was issued, November 29th, 2011. I wonder what else could be wrong on this. But apparently, since nobody's contacted me about that, I wonder if there'll be any follow-up or if this incorrect order will continue to, give the illusion of false process. Moving on. This is about an IDR over medical records, regarding the denial of medical care. There's many things here, and I will read for the record because part of the problem here in your order of determination, it doesn't list what I'd asked for specifically. For example, under number 2, I specifically asked for a copy of my HIPAA release for my Tom Waddell Healthcare to have been, I'm sorry, let me reread this. A copy of my medical records for both 2011, 2010 from Tom Waddell regarding these 2 incidents. I'm sorry, once again, I read the wrong line. Number 2, a copy of my signed HIPAA release for my Tom Waddell healthcare information to have been released through San Francisco General under DPH for Haight-Ashbury Free Clinic, for which San Francisco DPH was found in violation, and I list the violation or an admission of the law-breaking activity. On the order of determination, that's not what's listed under number 2, because that would mean that they would have to respond to the admission, which they didn't. Of course, in the November hearing, they said that they had provided the records, but then when it was further found out that they had provided the records from 2006, the bait and switch was never questioned by the task force. As a matter of fact, this whole HIPAA, all these law-breaking activities reminds me very much of my Impala violation at the Department of Public Health. These records, by law, have to be there. If they say they can't produce them, that's not my problem. By law, they must be there, and that is why I'm inserting this right now. So when the task force says, well, they don't have any records that are compliant, there's nothing we can do. By law, that record has to be there. And if it's not, then the second part of my request kicks in at admission. But to simply gloss over all of it, once again, perpetuates the illusion. Let's see. Number 3 was, like what I just said, the Department of Public Health trying to pass off a HIPAA form that was signed in 2006 as being applicable. They even did that to licensing and certification, which of course I notified them. Let's not forget that I've asked these people under what you guys have said that they needed to fill within 5 days, number 3 and number 4, which of course they did not fill within 5 days. Did not receive it, for the information as to the agencies to complain to for their law-breaking activity. And I can tell you that each and every agency that they've sent me to has denied being the proper agency. Oh, how convenient. They're supposed to be the knowledgeable people. They're supposed to know the answers to these questions. Why do they not? Oh, and by the way, speaking of a knowledgeable representative, I believe that in our November hearing, they didn't have a knowledgeable representative there to speak about medical records, because when the medical record stuff was asked about, nobody was there to talk about it. Now, I don't see Dr. Pace or the Director of Public Health, Barbara Garcia, here either. So once again, we're going to have an unknowledgeable person pulling your leg, which of course is probably what you want, says that you can wash your hands of this entire thing. Unfortunately, it still violates all my rights, all my due process, and everything else. But, what else is new at the Ministry of Sunshine? The illusion is wonderful. The outcome sucks. The morality, the inhumanity. To those of us who you have a duty, not to the other side who baits and switch and gives you the incorrect paperwork and then you gloss over it. Not to the other side who doesn't give you what's required by law to be in there, but somehow you overlook that. What have you done for me? For an IDR that I, for medical care and records that was back in August. An IDR! Do we know what an IDR stands for? Do we know what rolling basis stands for? Well, I still haven't gotten, what I requested. It's now what, January 10th? There isn't even a knowledgeable representative here. Oh, and as a matter of fact, your order of determination doesn't list where the other side, paints a picture of me as being hostile and all these things, when I continue to tell the truth that they're serial violators, and you guys don't even care, don't even take that into consideration, and don't realize that, once again, you're denying me due process.
Is there anyone here to offer facts and evidence in support of the complainant? Okay, is the respondent present?
Eileen Shields, Public Information Officer for the San Francisco Department of Public Health. I will stipulate to the response that I gave to the task force when they asked for us to come here this evening. You have that in writing. Happy to answer any questions.
Okay, excuse me, Ms. Shields. This is the communication dated December 9th?
Yes.
Okay, thank you. Is there anyone here to offer facts and evidence in support of the respondent? Okay, the matter is now with the task force. Member Nee?
Mr. Garza, please approach the microphone.
Certainly, kind sir.
Thank you. In the order of determination, it is specifically, there's a specific direction here that the instruction is to release. Jesus, where is this? Items 3 and 4 in your request. Item 3, documentation provided to state and federal regulatory agencies noticing an investigation and finding of a HIPAA violation against San Francisco General. And number 4, information on how to file a complaint against clinic security staff. So the question I have is, have you received those particular parts of your request?
First of all, I'm a little confused because shouldn't your question be whether or not I received them within 5 days?
Well, that's the second part of my question.
Okay. So in answer to your question then, for number 3, no, because the information I received was incorrect. And for number 4, no, because it was not, I'm sorry, I received it but not timely.
Okay. Thank you.
You're welcome.
Ms. Shields? You have heard the complainant state that he has not received item 4 in his public information request, information on how to file a complaint against clinic security staff. Item 3, he says he got late. Oh, the other way around. Okay, he has not received documentation provided to state and federal regulatory agencies noticing an investigation and finding of a HIPAA violation against San Francisco General. Is there a reason that he has not received that?
He has received that. He has received that. We have the order of determination was sent to us on December the 5th. We responded on December the 9th. And
Okay.
you have a copy of what we sent him. It was a repeat of what he had asked for before. We sent him a copy of that.
You sent it how? By postal mail? By email?
Email.
By email.
Yes.
In the email, in some email programs, I know in my own, which is Mozilla Thunderbird, there is an option to request a notice of delivery and notice that the email has been received by the intended recipient. Do you know if the email was set up that way so that when Mr. Garza received, when the message was delivered to Mr. Garza's inbox, you would receive notification of that, and when he opened it up, you would receive notification of that. Was that done?
I'm not able to do that unless it's within the system. I can do that if I send it to an sfgov.org person, but I can't do it to someone that's not within the city system.
Okay, so there's really no way of telling, you're telling us that it was sent.
It was sent because I have Mr. Garza then responded he wasn't happy with what I had sent. So
Okay.
I know that he got it.
Okay, that's fine. Thank you.
Madam Chair, I would just like to note for the record
Member
that
Wolf.
in the order of termination that the acronym for HIPAA is incorrect. The second P should be an A all the way through, just for typographical.
Madam Chair,
Member Nate?
as a matter of fact, I noticed, I sent a memo on that to Chair Johnson and to to our administrator, and they have been in contact with the city attorney regarding whether making the necessary corrections would require any kind of motion or anything like that, but it has come to their attention.
Okay. Mr. Garza, I have a question for you.
Certainly.
So we have a copy of the email sent to you by Ms. Shields on December 9th, and she is responding to your third request, which was part of the order of determination, and then there are some attachments here. What is it about this material that is what's missing, or
Well, for example, when I asked, I believe it was for the federal and state agencies for the HIPAA violation. I think that's what it covers. That's what it's germane about. I got sent the licensing and certification, and then I didn't get sent anything for the federal people. If you look, the packet includes stuff that they sent up to licensing and certification, but where is the federal notification? And let's not forget, HIPAA is a federal law. That's the state level that they say, oh, another bait and switch. And if you even look into that they sent, let us not forget that they sent in duplicitous, false information by submitting a form that had been crossed out in 2006 and wanting to slip it under the wire for a law-breaking activity they did in 2010 and 11. Also, while we're here, let's not forget item number 1, the medical records. Will we ever address that under HIPAA that I've not received to this date, or will that be glossed over, and will I have to re-IDR them again over that? I would like to know the answer to that also. We're talking about an IDR for records for denial of medical care. We're talking about duplicitous records that the Department of Public Health has already sent in, that was pointed out, like I said, at the hearing, and it just was glossed over by you guys. I guess my advocacy here doesn't matter. I guess my humanity, my medical needs, and everything that I paid into the system for as a disabled person, inclusive of my ADA rights and everything else, doesn't matter. Once again, we still don't have a knowledgeable representative here for my medical records. Is that going to be glossed over? Will I have to re-IDR them? Will this farce continue? And if so, for how much longer? Because I can tell you, I will never, ever give up.
Member Wolf?
Madam Chair, I just wanted to iterate that I had tried to make arrangements to have a HIPAA expert come here today, was unable to make it due to a family matter, and then got a call from 2 other agencies that stated that there was an action at the state building regarding the state budget regarding to various budget matters regarding with people with disabilities. So they said that they would be able to make it for our next meeting. And if we're interested in getting a third-party exclusive opinion about some of the matters that we're concerned about here today on this, then I would suggest we continue.
All right. Now, you're referring to information that would address his first request, a copy of his medical records.
Correct.
And I'm looking at the...
It's more about whether the requirement on how to request the records.
Mm-hmm.
I think we know that the records exist, and the city's policy is not to release those records unless a person signs a certain form. Now, the way we're trying to determine whether what's in HIPAA states that it's those signatures or those requests with a formal form was only applicable for third parties, people other than the individual that the records belong to. So if a member of the family or a friend or a lawyer or some other third party, an insurance company, requested those records, then the HIPAA is clear that that a specific form with specific information needs to be collected. But for the person, the person themselves, that's something different, and that's what we wanted to hear from a HIPAA expert about. And if actually reading the documents that are in here today, I mean, there is some indication. If we look on page 54, in the first bullet under your rights regarding health information about you, your right to ask and inspect a copy, all it says is that you must take or send your request in writing for the medical records. It doesn't state that you have to sign anybody else's form. All you have to do is present your own request in writing. And so that's the crux of Mr. Garza's issue here, is that he wants his records. Department of Health says we have them, but he's got to fill out this form. If he fills out the form, we'll give it to him happily. But he's contesting that he doesn't need to fill out a form. So that's the crux of why we had requested to have a HIPAA expert come and present today. Actually, it was supposed to be last meeting, but I was unable to make it myself.
All right. So you're suggesting that we continue this?
I would suggest, if the other members of the committee, agree and feel that that would be important for this, since it is kind of the crux of the whole case. Because once he gets that information, the question is what about, does everything else apply? And that's really the really number one is the basis of this whole thing.
Member Snyder?
I think that the testimony from the HIPAA official will be great and very interesting, but I don't think it's relevant here. We decided that there was no violation as to 1. If the order of determination makes clear that the only violations were as to 3 and 4. So I think the issue of whether the medical records being released was a violation is moot. It's already been decided. We can't override the task force here in the committee.
I'm not clear that's correct, because
well, read the order.
I know, but I'm not sure that that's correct.
Well, we found there were 2 issues. There were 2 complaints of Mr. Garza's that we heard. One was solely about the medical records.
Right.
I think.
Isn't that this one?
No, this one was a later one that we, I may be wrong, but I'm pretty sure that this one is a later one, and we found no violation as to the production of the medical records. What we found a violation to was as to 3 and 4, the documentation provided to state and federal regulatory agencies and information on how to file a complaint. I think that's all that's at issue before the committee right now.
Well, I'm a little confused then, because if you read at the bottom of page 38 to the top of page 39, it discusses that whole that whole matter. It's the bulk of the hearing. And I don't know why we would then request to have a HIPAA representative show up.
It's for future reference, I think.
Well,
Well, I think we just were not, as I recall that meeting, I think we were just unable to resolve that issue at all because we didn't have enough information. So we didn't say there was no violation. We didn't say there was a violation. We're moot on that.
I think
we found there
that's
was
correct.
no problem with 2 and 5. 3 and 4 had not been complied with, and so that's. But I think we were hoping to get some illumination from a HIPAA expert. And
Madam Chair, on page 39 at the bottom under findings, says, based on the statements of the complainant and respondent and the email exchanges provided and supporting documentation, the task force concluded additional research was required regarding the interpretation of HIPAA release requirements to an individual's own medical records. The task force was concerned about medical providers' right to adequately document release of protection. Task force, and so then it said task force further concluded that parts 2 and 5 of the request had been satisfied. So the matter is that that number 1 is still up in the air,
exactly.
and that's
exactly.
We're still needing to make that determination. To my recollection, we were supposed to gather that information, make a recommendation back to the task force so it can retake up that issue.
Exactly.
Because that is his original complaint.
Oh, yeah. Well, but we can still. That's an interesting procedural.
Yeah, the bulk of this was to be able to determine, because we have no idea. Is Mr. Garza correct or is the Department of Health correct? And really it needs that third party to answer it because we really haven't gotten a knowledgeable person regarding HIPAA on these matters to convince us. So we were supposed to determine based upon the expert advice or at least presentation, we could make some sort of recommendation as to what is correct and what's not. And then make a recommendation back to the task force to retake up that issue because really this particular case is really specific to number 1. Number 2 through 5 is really subsequent to that. It's because number 1 has not been satisfied.
Okay, so at this time I'd like to hear the rebuttals and then we can.
I just stand corrected. Number 2, I believe, was satisfied because it's included in the packet here.
Number 2 and also number 5.
And number 5, right.
Had been satisfied actually at the hearing before the full task force.
I just wanted to say one quick thing as point of order.
No, we're moving
I'll
on
wait.
to rebuttals. You'll have a chance in 1 minute. At this time, the respondent has 3 minutes to offer a rebuttal.
I would just restate what I have put in writing to the Sunshine Task Force. And one other question, and that is, the question I guess becomes is, are medical records under the purview of the Sunshine Task Force? Thank you.
Thank you. At this time, the complainant has 3 minutes to make a rebuttal.
I just wanted to make one quick point of order, just something that, Mr. Wolf said about, no idea, no previous, no yada, 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 HIPAA, we don't know, yada, yada, yada. False. Incorrect. Go back, search your records for the task force. I had previously requested my medical records from DPH when I was denied emergency services at San Francisco General in 2001, and in 2 different occasions without signing a HIPAA release, the task force found in my favor. I submitted that paperwork to the task force already. So for the statement to say that we don't know, yada, 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 is not factual. There is stuff in the prior task force's arena where the determinations have already been made, which was another interesting thing because I wrote to you guys and said, well, what about precedents? What about all the prior decisions that of course, no response. Of course, naturally. What else is new? Anyway, will I have to die before I receive any justice? How much longer is this going to go on? I'm a disabled person. My blood pressure goes up. I have an adjustment disorder. I cannot adjust a disorder. That's all I get here. That's all I get from the other side. You're setting my disorder off. You're setting my disability off. You're harming me. I wanted to interject that for the record, for reasonable people. The Department of Public Health knows this. Dr. Pachi knows this. Barbara Garcia knows this. Yet a knowledgeable representative from their point couldn't have been sent here. You couldn't have asked them. Why? Where's my due process? Thank you.
Members? Member Wolf.
I'll leave it up to maybe the other members to determine what the dispensation for 2 and 5 are. With relation to number 1, I would like to hold over part of this. I would like to hold over part of this case so that we can have a HIPAA representative come and actually help us determine with regards to the form whether that was required. With regards to what's happened in the past, laws change, and we have to be updated. So even though the task force may have made determinations in favor or against in the past, we're talking 10 years ago, 12 years ago, and laws at the federal level can change, and so can these technicalities. So I think it's worthwhile for us to be educated about it, as we have on other matters, and move on from there to make sure we're making appropriate decisions.
I just want to make a correction. The full task force determined that Mr. Garza had received information for number 2 and number 5. So part of what our committee was supposed to determine this evening was whether 3 and 4 had been complied with.
Where? Page 38.
Order of determination, right. On page 40. Or I guess it's the findings of fact. So the task force, bottom of page 39, the task force further concluded that parts 2 and 5 of the request had been satisfied. Page 2 of the order of determination. Okay. Then the top of the next page, based on the respondent's own admissions,
Right, he spelled out the
3 and
numbers.
4.
Okay.
And so Ms. Shields is representing that and has provided documentation for providing records and information for 3 and 4, which appears to have been done in a timely fashion because they received this on December 6th and the emails dated December 9th.
Madam Chair, I think it would be appropriate to request that people in the audience section remain quiet during our deliberations.
Yeah, if you would allow us to discuss this matter without interruption, we would appreciate it. Okay. Do I hear a motion? Member Nee.
Madam Chair, I move to continue this matter to our next meeting in order to enable us to hear from people who can provide us with expertise on the HIPAA-related matters.
Second.
Okay, is there any public comment on the motion before us to continue this?
The motion is to continue this to the next meeting, is that right?
So that we can hear from an expert on HIPAA.
Okay. I think the fact is that the task force must have determined that Mr. Garza's records, medical records, are public records. because they're involved in the people's business. So the issue then is whether there's an exemption from disclosure. Under the Public Records Act, they had 10 days to notify Mr. Garza from the time he asked for those records, whether they were exempt or not, and to point out what that exemption was. And the exemptions are found in the Public Records Act. There's a long list of them at some point. Not having done that, as I understand it, the records are not public records. They're not exempt because they haven't identified the exemption under the Public Records Act, and they haven't given any other reason other than there's some federal law that may or may not preempt them from doing it. I see no reason why they can't give him his own medical records when he asks for them. And I don't see any reason to get an expert to tell you what the federal law might be when it may not even be subject to the federal law under the way the Public Records Act and the Sunshine Ordinance work. And that's your purview. That's what defines your ability to act or not act on a given complaint. The Public Records Act and the Sunshine Ordinance.
Thank you.
Hello, Rita O'Flynn. I'm offering these comments in the hope that it might be helpful to you. I work as a consultant in the pharmaceutical biotech industry, primarily in clinical research, and I deal with issues of HIPAA and disclosure of patient records on a frequent basis. One of the concerns that prompted me to stand up and speak about this matter, which I'm not that familiar with, was the comment that the Department of Public Health considers Mr. Garza's medical records to be their medical records. Based on my experience, these medical records are Mr. Garza's medical records, and the failure to disclose these to him places him and his health at risk. Should Mr. Garza tomorrow decide to have some sort of a medical emergency and arrive at a different facility that does not have these records, it could affect the quality of his care, and it could affect the outcome of such a visit to the hospital. I just wanted you to be aware that that's the purpose of, that's why HIPAA has those statements in there saying that the patient can have their medical records. It's for just that type of eventuality. It's his health, it's his well-being. That's paramount here. Thank you.
Thank you.
Thomas Piccirillo. I would agree with Mr. Grossman that continuance is really not appropriate. Medical records of the claimant are public records and his own. I was treated at San Francisco General Hospital last year. Chemotherapy, CAT scans, the whole works. I did an IDR to respondent, Shields. I got my records in 2 days. I just went to the hospital and picked them up. There wasn't anything to sign other than me signing and say I got my records. If there's a HIPAA defense, the burden is on the respondent. You shouldn't have to independently get testimony from somebody with HIPAA knowledge. It's a defense, then it's on the burden by the respondent to prove why they didn't provide the records. But I can tell you, in my personal experience, I got all my medical records in 2 days after I did an IDR to Ms. Shields. Thank you.
Member Wolf.
So a couple of things. With regards to member of the public, Mr. Grossman's statement, I don't have the CPRA area sections in front of me, but there are sections that exempt certain kinds of documents. It was my contention through my own personal experiences, as Mr. Piccirillo had just noted, that I personally have never had to sign to get my own personal records when I requested them. Sometimes I'm asked to do it in writing, but then I just show up and they're there. And But in all respects to Mr. Piccirillo, you did mention that you had to sign some document just for tracking purposes, that you received them. And that is part of the testimony that the Department of Health has been contending, is that they have, in one sense, they said that they want a form pre-getting them, and the other side, at another time, they'll say they want a record that the records were received. And what the question is what is the form? What is the form for a part of the request, or is the form part of just reception? And so that becomes the contention here of what we want to find out. And that's why we want to hear from a HIPAA expert, because that way we don't have to guess. That way we will know for sure. And that way it's the same thing like what we had to deal with years ago around metadata and around a whole load of other things, around very technical aspects that some of us on the task force know about, but can't necessarily convince the rest of the task force for. And we shouldn't have to do that. We should be educated by experts, by lawyers, or by whoever, to be able to, by third parties, so that we know for sure that we're making the right decisions and not making the wrong decisions. So I think, where we stand in continuing this is of value.
I just have a question for Ms. Shields. I'm thinking about all I've heard and feeling a little confused. So, Ms. Shields, I'm wondering if I say I received some treatment at San Francisco General, and I came to the hospital several months later and went to medical records and said I'd like a copy of my records of being treated on such and such a date, what would happen then?
You would be asked probably to just fill out a form saying you're asking for your records. They would give them to you. Then you fill out something that really would serve as a receipt saying, I got my records. You'd also have to show ID.
Okay, well, I understand the ID part. So,
and Mr. Garza needs only show up at down at Tom Waddell Health Center. The records were ready for him. All he has to do is show up there and sign that he got them. That's all we're asking him. So we've not denied him the records. What we've done is denied him access to the records unless he signs, and he refuses to go there, and he refuses to go there and sign. So our hands are tied.
And this requirement that you signed to indicate that you've received the records, this is the authority for requiring that comes from whom?
My understanding it comes from HIPAA, and I'm sorry I'm not articulate on the HIPAA regulations because my office has always separated medical records from public records. And if someone wants a medical record, I always just send them to the medical records division of wherever it is that they're wanting from. And I've never, ever had any problem, just like as the gentleman, yeah. And I made it clear to him they weren't medical records, so I couldn't give them to him through my office, but I made provisions for him to go get them. We've done that for Mr. Garza as well.
Okay, thank you. All right. So no, I haven't asked for public comment, actually. Well, yeah, I did. I'm really getting tangled up here. Go ahead.
I definitely see it more as like if I have a file, then I should be able to ask for it and get it. So I think that, and then the other thing too is her office is somewhere else. So her office is somewhere else, like on the second floor. And the thing is she's the public information officer. The way the website reads is like if I ask for information, I'm supposed to go through her to get all the information. So the reason why she can't produce the medical records or have somebody to give it to her so that she can give it to them, something doesn't seem appropriate. I'm just thinking with other cases when I would, I asked one body I asked a nonprofit to give me a copy of my records, and eventually I got them. So there are parallels where I can just ask for confidential information that's mine and receive it. I think the other thing too is it just also seems that Garcia, he asked for some records, but then he got something else that was not relevant to what he was asking. So it's almost like they ignored or denied his request because they just sent him something else. So if I ask for something and then they send me like a copy of the Constitution of which I didn't ask for, it's kind of like a violation.
Thank you. All right. Any further discussion from the task force? Okay. Ms. Johnson, would you call the roll on the motion, please?
On the motion to continue, Member Snyder. Snyder absent. Member Nee.
Aye.
Nee, aye. Member Wolf.
Aye.
Wolf, aye. Member Washburn.
Aye.
Washburn, aye. Madam Chair, there are 3 ayes.
So will this come, Member Wolf, do you want this to come back to this
To
body?
this body.
Okay. All right. So this will be on the calendar for the next meeting. Ms. Johnson, would you call the next item on the agenda?
Item 6, next steps on Ethics Commission's proposed policy for handling sunshine-related complaints.
Okay, I'd like to inform the other committee members and members of the public that I had written a letter to the ethics commissioners in mid-December. The letter was dated December 16th. And this letter was requesting a meeting, joint meeting with the Ethics Commission the week of February 6th. I also said if there was no date that week that we would entertain other weeks as well. And that prior to that date, we would be sending them some information or some memoranda regarding Excuse me.
Excuse me. If your case is over, if you want to sit and listen, that's fine. If you have other business to do, take it outside.
Excuse
Okay,
me.
We're not going to do this here, okay?
Okay,
Sorry.
We've moved on to the next item on the agenda, and I would appreciate if.
Ms.
We've moved on to a very important item, item number, not that the other one wasn't important, number 6. I was just updating everyone about next steps. So a letter was drafted December 16th. It was sent, according to Mr. Rustum, on December 16th to members of the Ethics Commission. It was CC'd to Supervisor Campos, with whom Mr. Grossman and I met several days prior. He has indicated a willingness to support this meeting happening. He's also planning to hold another meeting about this matter. And I indicated in the first paragraph of the letter that I had sent an earlier letter requesting a meeting and never heard a response. So just to let you know, we haven't yet heard from the Ethics Commission about our proposal for a joint meeting. So that's where the matter stands.
Is there
Sort
some
of
violation there of not responding within a certain period of time?
I don't think so. I think there's a matter of courtesy, decorum, professionalism, all kinds of, violations, nothing official. So I've been contemplating how long to give them before I send a follow-up letter. So that's kind of where this stands. In the meantime, Mr. Grossman, he's been very busy working on, follow-up to their response to our response to their original regulations, and has actually forwarded in the past couple of days a couple of more memoranda. So, Member Nee.
Yes. Madam Chair, I would suggest that our next communication to the Ethics Commission be well in advance of their next meeting. And at that next meeting, at least one of us should be there to just reinforce our message that we want to have a meeting. This committee wants to have a meeting with ethics. The sooner the better.
Member Wolf?
Yeah, I would say based upon the timeline of them sending their original letter and you're making the response, and now we still haven't heard. It's, what, 3 weeks, 4 weeks, almost 4 weeks
There was a holiday there, so
I
it's
understand.
giving them some.
But still adding, we're now 2 weeks, almost 3 weeks into the new year. I think
And-
it's worthwhile to send them a reminder.
Right, and the week of February 6th
Right.
is going to soon be on us. I need to send a follow-up letter, and we also, immediately, and so we should
Might
appear.
I suggest that you might ask them, because they've not availed themselves to meet with us, to actually postpone their decision on February 6th?
Okay. There's also there's an opportunity to, on their meeting February 23rd. January 23rd is their meeting. And it's going to be a momentous one. It's going to be televised. So I know that there will be members of the public there to speak their minds about a lot of what has transpired or not transpired. So we should make sure that we show up. I don't know if we show up in force, or one of us, or what's the, do we want to be prudent, or do we want to be?
Well, I don't see a problem in all of us showing up. It's not really an item. It's within our jurisdiction, but it's not really an item that's, that's of action before us.
Madam Chair, I don't think that the presence or absence of televising on TV cameras should be a determining factor here. We have business with the Ethics Commission. We should proceed accordingly. That's my opinion. Whether we show up en masse, I would say that's up to the individual task force members.
I think, personally, I think that a follow-up letter immediately is in order, and because of the timing of the whole thing. I know that I want to attend the meeting on the 23rd as chair of this committee that has been working on this matter, and speak to the need for them to postpone making a decision until we have this joint meeting and deliberate.
Great.
So I have your support.
Absolutely.
Okay. At this time, I'd like to hear from members of the public.
If the joint meeting is scheduled sometime the week of February 5th, according to your letter, you have to get to the commission at least a week prior to that meeting, the comments of the task force of this committee on the proposed regulations, so that there's some basis for a discussion of what you consider the problems to be and how they want to handle it, which raises the question of how those comments are going to be put together, by whom, and by what process. The Ethics Commission has 2 full-time lawyers on staff, at least 2. It has 2 deputy city attorneys that are usually advising it. The task force has 1 lawyer member and a part-time deputy city attorney. As a result, I would say almost all of the work that's been done today on the ethics original sets of proposed regulations and the new set have been done by me in kind of a ex officio, or however you want to call it, status. But and I've done all of the work I think I can do on it now. I've got several memoranda, and I think I've highlighted the problems with the regulations if they were to go forward, not the least of which I mentioned earlier, which is you can forget about any enforcement out of ethics. The Attorney General won't enforce, and we know the district attorney will not enforce, and that leaves people who are complainants with no place to go but the Superior Court of the City and County of San Francisco, which we know is not a very good forum in terms of time or cost or you name it. However, if you had a full-time lawyer representing the task force, if Mr. Threet were full-time and if he were your advocate as required under the charter, under the ordinance, he would be doing 90% of the work because that would be his job. Mr. Snyder, who has indicated that he has no time to do any work on this, would then be probably asked to do some, review and, oversight and so forth. The point I'm trying to make is that it's time for the 2 grown-ups to get involved. And what I've done is I put together a package of a couple of memoranda, including one that demonstrates what's going to happen. It's like the people who talk about a nuclear war. What's going to happen if these regulations get adopted in the way St. Croix has put them together, which means that you'll never get any enforcement out of ethics for all practical purposes. And what I'd like to do is submit the package. I'll send it to the chair and to Mr. Rustum, so if anybody wants to see it and wants to do something with it, they're more than welcome. And I will be available if there are questions regarding what I've written. I'll be very happy to take the time to explain it, hopefully in an understandable fashion. Thank you.
Thank you. Member Wolf?
Yeah, with regards to Mr. Grossman's, I know we're not going to cut any further public comment off. I'm just commenting in between to keep the flow of the same topic. If you change the topic and I come back, it just disrupts the flow of the same topics. Mr. Grossman, I just wanted, it's because you've done so much work on this, I wanted to ask you, Chair Johnson and I have had some discussions with DCA3 with regards to other outside work that may need to be done, and he has expressed some openness to receiving some directive on items that need specific legal work.
You're talking about Mr. Threet?
Mr. Threet. So if you could provide those items that you feel that are now beyond your ability or your time factor, I could present those with Chair Johnson to DCA 3 and identify, really in a time frame before February 6th that how much of this can be done.
Well, as I indicated, you're more than welcome to have everything I've got. Totally.
Okay. Do you have a list of the items that you feel that it's still in need of work, so that are they identified specifically?
Well, it really goes to how well I did it.
I see.
And there are lawyers who will do a better job, I assure you.
Okay. All right. Well, we can do that if we want to submit it for review.
The only caution I would give you is that from what I've seen of Mr. Threet's work, although everybody who I've talked to about him thinks he's a really fair-minded individual, I'm not so sure he's your advocate, which is it's a harder aspect to it.
Yeah, I hear you. I mean, unless we want to present it to someone else, it's. Well, I just wanted to express that to you, Madam Chair, because.
No, I think asking DCA 3 to take a look at these materials is in order, and I think we need to, when we present the materials to him, make it clear that we want him to approach these as our attorney, our advocate. Remind him of that. We don't want him to be looking at these as representing city departments or, heaven forbid, the Ethics Commission. This is representing us.
Okay.
And that we're familiar with a lot of Mr. Grossman's arguments now. As a committee, we understand and we support what he's saying. So,
if you can provide me with Mr. Grossman's work, then
he's going to send. He's going to send it to.
He'll send it. Perfect.
To Mr. Rustum and.
Okay.
Yeah,
perfect.
Okay.
Great. Thank you.
Rita O'Flynn. I'm also someone who's gone
Can you
through.
pull the microphone a little bit closer to you?
I'm also someone who has explored the administrative avenues available to me, first by going through the Sunshine Ordinance Task Force, which then wound up in a referral to the Ethics Commission. There are currently no rules and regulations regarding how long the Ethics Commission has to respond to one of your orders of determination. Obviously, there's nothing that tells them when they need to respond to your letters. You may want to put a response date in your next letter to see if that does something. But I'm hoping that what will be the outcome of this will be an enforcing of the Sunshine Ordinance Task Force. My personal experience is that my experience with the task force was that you are knowledgeable of the law, your application of it was more than fair, you were very patient, very understanding, really allowing all sides to try and make their case. For you to come to an order of determination after the years that you sometimes put into these issues, where you make a determination that there is a violation, to have that go to the committee and have the Ethics Commission and have them dismiss your work and minimalize it should not be acceptable. The Ethics Commission at this point should only be saying whether or not they're going to enforce your findings or not, and not reinvestigate them and come up with entirely different conclusions. In my own case, the final report that was issued by the Commission stated that I was non-responsive to requests to participate in their investigation. That simply isn't true. I requested that my communication with them and my participation be in a documentable form, such as asking me questions in email, and I would respond them in email. That's my right to do that. And in fact, the draft report indicated that I would only participate if I could have that right. The final report, and I don't know who changed it, indicated that I was non-responsive to requests to participate in the process. This should not be allowed. This is just appalling. At this point, I too have decided to go for the Superior Court of San Francisco route. It's going to cost me hundreds of thousands of dollars that I don't have. I'll take it out of my retirement fund, but quite frankly, I don't have any other choice. It would be easier for me if you guys had the authority to go with your responsibilities. Thank you.
Thank you.
Thomas Piccarello. I applaud your decision to make the request to have a joint meeting with the Ethics Commission. Many of us have been advocating that for a long time. I don't think you're going to resolve anything in the first meeting, if there is one that takes place. So, perhaps you can have informal meetings with them, and they don't have to be televised, and they don't have to be in a Sunshine Ordinance Task Force meeting. You can have informal meetings prior to, you getting down to the nuts and bolts as to disagreements and what both sides are proposing. So on January 23rd, as you know, the Ethics Commission will be meeting and discussing new methods of enforcement of sunshine violations. Perhaps from that meeting, then you'll be able to make some suggestions to the Ethics Commission if you disagree with some of the proposals that they are making on the 23rd. Thank you.
Thank you. Are there any further public comments on this matter? Okay.
Yeah, I recommend that you do have that meeting, but also several other meetings, possibly a subcommittee or something to hash out some of the issues so that you can become clear as to what you both have plans on doing. That might be the best way to do it.
Thank you. Ms. Johnson, would you call the next item on the agenda?
Item 8, Administrator's Report.
Is there any public comment on the Administrator's Report? Any comments from the members? Okay, seeing none, would you call the next item on the agenda, Ms. Johnson? Oh.
Item 9, Announcements, Comments, Questions, and Future Agenda Items.
Member Wolf.
So I would suggest that we start agendizing the amendments to the task force, to the Sunshine Ordinance, considering we have 2 elections coming up. I don't think we'll make it for the June election.
No.
But at least for the November election, we should seek to try and get as many or the most important ones that might have a significant effect and make a decision about which ones those should be and our strategy.
Okay. So at our next meeting next month, we should put amendments back on the agenda. So I'd like to direct Mr. Rustum to do so. Any further announcements, comments? Do I hear a motion to adjourn the meeting?
So move.
Without objection. Meeting's adjourned at 6:52.